Yes.
Just moving now to the judge's conclusion that he reached. In paragraph 43 of the judgment, which is quoted in the Learned Friend's skeleton argument on page 55, if that's easier to find. The judge set out his reasoning on the note, and he said even this doesn't go far enough. In the context of an interlocutory hearing where the note, let alone many of the points broached with me more elliptically, were not explored fully in submissions, let alone the evidence. And at the bottom, referring to the BIT tribunal, I'm not able merely to adopt their conclusions because they're subject to claimant's challenges, nor am I able to reach my own conclusions. The limited nature of the hearing before me simply did not make this possible. Just pausing there, it was never our case that the judge was required simply merely to adopt their conclusions at all. He was entitled to look at the primary evidence and see what it showed, and to consider the reasoning of the tribunal and give it such weight as its cogency merited. And that, I think, is clear from Dalla. The Learned Friend says that only applies to the issue of jurisdiction itself. We say it applies equally on findings that the tribunal made on the note, which were very clear. Now, Learned Judges professed an ability to reach the conclusions. There are three aspects of that. Firstly, we respectfully say that if he'd approached the threshold for reaching a conclusion that he should have done, he would have been able to reach the necessary conclusion, because the courts are, as my Lord Justice Males said in his reasons, very familiar, well used to deciding, even without a final hearing, those sorts of points. The second point in relation to that is the timing point, that the judge felt there wasn't enough time to deal with all the points, and he felt under pressure in the way that he's indicated.
Is it right that at the hearing below, in contrast with your position in this court, you were relying not just on the note, but on the whole run of behaviour which you took objection to?
My Lord, yes. My learned friend Mr. Riches opened it much more widely because he was still contesting security for costs.
Yes.
What happened in relation to that, and we can see, I will take the court to the transcript in a minute, is that fairly soon after Mr. Baston was on his feet, the judge put to him that nowhere had the Czech Republic ever said they were going to pay costs, and tested him. Can I just show the court that very quickly?
Well, if you want to, but I think
I'll use my time.
You've answered my question,
yeah.
which is what I wanted to know.
Yes, and effectively, the security for costs issue was resolved as soon as Mr. Baston had got on his feet, because the judge said, "Well, why have you not said that you will honour a cost order? That's normally the first thing that happens." And then, as the court will see, my friend then said, "Well, I'm not able to confirm that costs will be paid," and then afterwards said he was able to give an undertaking to the court when the judge pressed him a little further. So that's how security for costs was dealt with, but it had the approach that the Czech Republic had taken meant that Mr. Riches had gone certainly wider. I accept your Lordship's point. It wasn't.
I mean, the difference is that in the court below, the judge was confronted with a forest, whereas here we're confronted with a tree.
Yes, my Lord, to be fair, and that's a completely fair point. It was more like a few saplings around a large oak, in fact. And you can see that from the transcript. I can take you to that in a second. But just before I do, can I just invite the court just to look very quickly at the White Book at 2 points. First of all, sorry, it's in volume 2. I can just tell the court, actually, it's more easier.
Mm-hmm.
The two short points are that White Book Volume 2, page 706, at O8.11, specifically in relation to application numbers 76 and 77, it says, save in exceptional circumstances, any such application should be marked with a time estimate of 1 hour or less and listed to be heard on the first available Friday after issue. So that's what the Commercial Court Guide says, in save in exceptional circumstances, which we respectfully say informs the nature of the inquiry that the judge is undertaking. The second point in relation to that is that the learned friend's skeleton suggests that, that paragraph 15 of the skeleton suggests that it's all the applicant's fault for not listing it properly and for long enough, and it's the applicant's responsibility. He says on page 37, bottom of paragraph 15, 4 lines up from the bottom, it's the responsibility of an applicant to assure the time estimate of the hearing is accurate, and an applicant obviously cannot give an estimate assuming half of its applications will be agreed before the hearing, etc. Now, in fact, what the Commercial Court Guide says in relation to that is is on page 682 and at F5.6b, if at any time either party considers there's a material risk the hearing of the application will exceed the time currently allowed, it must inform the listing office immediately. And so the Czech Republic went into the hearing on the basis that a day simply was inadequate, and submitted to the judge that a day was simply inadequate time for the judge to consider all those points, yet had not drawn that to the attention of listing beforehand. That's the first point. The second point, if I can ask the court quickly to go very kindly to the transcript in bundle S2, supplemental bundle 2, in tab 13. And it's at page 249. And at the top of the page, page little 149, the judge says, I'm just making the point that merits were not in play in that case, at all in the same way as they put in play in this case. I'm not really seeing the comparison. And then in the context of that, if we go down to the bottom at 150, line 15, Mr. Baston, of course, my lord, the Czech Republic doesn't accept the factual findings as being correct. Of course, it's produced an award, but the contentions. And the judge says, I'm just going to repeat that. Mr. Richards, for convenience, took me to the award, but he's not saying you must accept this because it's written down in an award. He's saying, look at what the arbitrators actually say. They identify a document whose contents you can read for yourself. And learned friend says, and you're right, my lord, that's exactly what the award does. But I think ultimately you fall back on that point of principle. If Section 67 challenges be affected by the merits, then it's difficult to know when that will not be the case. There will be findings against every Section 67 applicant. Mr. Sprite, I'm going to repeat again the fact that don't confuse the merits of security for cost application with the merits of the issues that are ultimately at stake in this action. They may in fact overlap, in a lot of respects, in this case they do. But the fact that in a case like Azov, where there was no such overlap, meant that looking at the merits was immaterial, doesn't mean it's also immaterial to look at the merits where they are, what I rather lazily call dirty dog points, which are critical to the exercise of discretion on a matter like security for costs. And Miller friend says limit to how much the court can engage with that. And then top of 152, line 2, Mr. Justice Bright. Yes, again, but that's to do with an investigation. And I think that's to do with investigation of the merits of the case itself. What it's suggesting you don't do is decide who's going to win or lose ultimately. That's not what Mr. Rich is trying to persuade me. And then he says, line 13, it's a different point entirely. That's timing. But to persuade me, for example, there is what one called a note that is set out the translations and so forth. And he says he's persuaded me that that document does exist, exists, and over the page, at the top of 250, line 3, the findings of the tribunal do not matter for this purpose. And then he says, I'm prepared to, line 6, prepared to find that document exists, says what it says, and then talks, I won't, if the court might kindly read 153 down to the bottom, 154, the response to Mr. Justice Bright saying, they're saying these are thoroughly untrustworthy people who are exactly the kind of people who cannot be relied upon to comply with court orders and pay costs if made against them. And my learned friend essentially says that the document is entirely irrelevant. So, in fact, the learned judge was well aware of the basis upon which he was being invited to consider the note, albeit that discussion arose primarily in relation to security for costs. But he was perfectly prepared in argument it was clear he understood exactly what was being said to him, and it was clear that he understood the approach that was being taken, and it was clear that he was prepared on the face of it to accept the document existed and said what it said. And on that basis, if that is where a judge goes to, it is not an available option then to ignore it and say I'm unable to make a finding, either because I'd have to make finding on everything, which we don't say is necessary, that's a wrong approach, which is one of the reasons he gave, or because he's unable to reach a conclusion when in fact he'd reached the necessary impressionistic view, which was appropriate for the application which he was seized with. So that's that point. And then there's only a couple of other small points, if I can just identify them quickly. My learned friend on pages 47 and 48 of his skeleton deals with the section 67 and section 68 challenges together and says you shouldn't be worse off in a section 67 challenge just because you brought a section 68. We respectfully say you shouldn't be better off in a 68 challenge if you've also brought a 67 challenge. And the judge mooted with my learned friend the possibility of making a different order in relation to the 68 challenge, which has presumptive validity, than would be made in relation to section 67. We say that's a perfectly proper course, and it was right for the judge to at least entertain that possibility, but he didn't follow it up because of the view that he took on the findings of fact. Learned friend takes a point in his skeleton at paragraph 57 on page 51 to 2 that our suggestion that the effect of the challenge to the award of the bilateral investment treaty tribunal is that the Czech Republic is seeking to basically restore the position that the 2008 award is not enforceable under the convention by their challenge. That is in fact what they're doing. Another friend says that's inconsistent with our case. And my lord, it's right that we would wish to contend that the 2008 award would still be valid and enforceable. But the difficulty is, as the BIT tribunal itself recalls in paragraph 218 on page 64 in bundle S1, there are numerous jurisdictions in which it's been held that because of the review, the 2008 cannot be enforced. So my learned friend saying it's inconsistent with the position we wish to advance in other jurisdictions does not detract from the position that we have advanced. Finally, two quick references to cases, and then I'm done. The court will have seen the decision in Mikula in the Court of Appeal, in which the Court of Appeal made an order of £150 million by way of security. That is, Mikula is in the bundle at tab 21, which is in A2. Go there. It's a relatively short point. What happened although the Court of Appeal was overturned in the Supreme Court in Nicola, on the primary point, what actually happened, if the court looks at page 616, para 247, was that it was clear that on one statute, the 1966 Act, it was an ICSID case, the court was obliged to enforce, and on the basis of the 1972, originally European Communities Act, the treaty was incorporated and there's obligation of sincere cooperation. And the court felt that it needed to yield to sincere cooperation effectively by staying enforcement pending action by the Commission. And D, if the obligation cannot currently be complied with, the English court should in principle do the next best to permitting enforcement. The next best that can be achieved without potentially violating EU law is to order Romania to provide security. And the court ordered security in the sum of £150 million in that case. And then we ultimately won in the Supreme Court on the primary point. The Supreme Court didn't say there was anything wrong about the security that was ordered by the Court of Appeal. And let me immediately say to the court that's obviously a completely different case in many respects. However, the point here is that the context of the 2008 award having been defeated by the corrupt conduct of the Czech Republic, combined with the fact that the Czech Republic positively asserts in its skeleton argument that the award itself is the remedy for that wrongdoing, and that is the award that's being challenged, puts the court in the position, the particular position, an unusual position, of seeking to do justice by reflecting the unusual and specific facts in the exercise of its discretion under Section 77. And finally, just two or three lines from Stati.
Your previous point was finally, but this is the last one, is it?
Sorry, was it finally the last? Yeah, this is the very last one. I apologise. Stati is also in the same bundle at tab 18. It's a short policy point on 503. At paragraph 93, and the court will see there, Mr. Justice Knowles, it will do nothing for the integrity of arbitration as a process, or its supervision by the courts, or the New York Convention, and then separately, or for the enforcement of arbitration awards in various countries, if the fraud allegations in the present case are not examined at trial and decided on their merits. Now, that's obviously considering something different. That's the importance of the examination of a fraud allegation. But we respectfully rely on that as identifying the very policy consideration of the integrity of arbitration and the New York Convention, which underpin what we say ought to be the proper response of this court to these facts. My lords, my lady, unless I can assist further on any particular points.
No, thank you very much, Mr. Baston.
My lords, my lady, I will start with jurisdiction. My lords, my lady, I will start with jurisdiction. I will then come to conditionality, and then I will make our submissions on section 77. I've heard what your lordship has indicated in relation to permission to appeal, and therefore I will deal with those submissions in response to the appeal itself. Our position, of course, remains, however, that permission can rightly be denied in this case. If that is not so, then the appeal ought to be dismissed. On jurisdiction, my learned friend's core argument is that a Section 70, subsection 7 decision is not a decision under Section 67-68 because it is not a decision tied to the substantive decision-making process in the challenge. We say that that is incorrect. I will start with the Act, and then I'll come to some of the practicalities of my learned friend's argument. On the Act, we have a point of construction, a point of policy, and a point on the authority. On the point of construction, the connection of Section 70 with Section 67-68 is well.
Sorry, I have to ask you to move the microphone. Thank you very much.
We'll see how that trick goes. My lords, my lady, on the point of construction, the connection of Section 70 with Section 67-68 is well known. As the court is aware, the critical question is what constitutes a decision under Section 67 and 68, and whether that includes a decision under Section 70, paragraph 7. My lords, my lady, if we can go first to the Act itself, in particular Section 70, Authority Bundle, tab 1, page 34. I wish to start with subparagraph 1. You can see there, my lords, my lady, that it reads, the following provisions apply to an application or appeal under Section 67, 68 or 69. Now, this provision was not referred to this morning by my learned friend, but our position is that this is a clear textual indicator that decisions under Section 70, and for today's purposes, paragraph 7, are a part of the process of reaching a decision under Section 67 and 68. The only life that the provisions in Section 70 have is in the application or the appeal under Section 67, 68 or 69. That of course includes a request for security for the award under Section 70, subsection 7. There can be no order for security for the award unless a challenge or an appeal under Section 67 to 69 exists. You turn over the page, my lords, my lady, and you look at paragraph 7 in particular, you can see there that it is explicit that it only operates in the context of, and I quote, pending the determination of the application or appeal. That being a reference, of course, to Section 67 to 69. If one turns back over to the start of the provision, one can see that my submissions just now are also consistent with the heading of the provision. It is consistent with it being described as a supplementary provision to Section 67 to 69. We say that these provisions in Section 70 are ancillary provisions which apply in an application under those provisions of Section 67 to 69. But there is a further point, my lords, my lady, which derives from the location of Section 70 and Sections 67 to 69 in the Act. It's perhaps not as easy to see in the printed version compared to when one logs on online. But if the court can turn back to page 30 in the bundle, you can see that the sub-part for Part 1 of the Act begins with Section 66. The title there for that sub-part is Powers of the Court in relation to award. Sections 66 through 71 comprise that subpart. that places section 70, again, in close connection with sections 67 to 69. Those are the statutory terms and the statutory framework that I now wish to make submissions on. As we've just seen, this subpart of the Act sets out the powers of the court. The bulk of this subpart is comprised by sections 67 to 69 and the provisions in sections 70 to 71, which are described as supplementary to, for the effect of an order on, a challenge or appeal under section 67 to 69. Within this subpart, the Act describes the different powers the court may exercise when determining a section 67 to 69 challenge or appeal. A number of those powers are in section 70. The powers therein are decisions applicable to a challenge or appeal under section 67 to 69. That is the language that I took you to in the first subparagraph of section 70. Given that these powers only exist in the context of a section 67 to 69 challenge or appeal, a decision in exercise of those powers in section 70 is a decision under section 67 to 69. Indeed, there is no process in which the powers in section 70 can result in a decision other than the process in section 67 to 69. The exercise of such powers in section 70 have to be a part of the process of section 67 to 69, as they are activated only in the context of such a challenge or appeal. I will come to the authorities in a moment, my lords, my lady, including NIOC. But we say that the issue before you today is in fact easier or clearer than the one that was decided by this court in NIOC, where, of course, as you'll recall, considered whether a section 73 decision was a decision under section 667 and 68. And I say that because if one asks whether a decision under section 70 is entirely ancillary or has no independent operation separate from a challenge or an appeal in section 67 to 69, we say that the answer is clear on the face of the Act. By the terms of section 70, paragraph 1 and paragraph 7, by the location of section 70 in the same subpart of the Act, and by its description as supplementary to section 67 to 69, we say it is clear that a decision pursuant to section 70, paragraph 7, is a part of the process of deciding a challenge or appeal under section 67 to 69. We respectfully submit that everything that your lordships and your ladyship need to decide the issue before you is contained within this subpart of the Act. A section 70, subsection 7 decision can only be made ancillary to a challenge or appeal, and thus is a decision of the first instance court under section 67 to 69. My lords, my lady, I want to deal with one point that arose during the discussion with my learned friend this morning. It relates to section 70, subsection 8. In the bundle, that provision is at page 35 of tab 1 of the authorities. There was a discussion of whether the Court of Appeal's powers encompass the power of the first instance court, which discussion was provoked by the identification of the second word in that subsection. Our respectful submission is that that discussion does not assist your lordships and your ladyship. Section 70, subsection 8, talks about who can grant leave to appeal subject to conditions. That answer of who is provided in section 105, which is at page 52 of tab 1 of the authority bundle. I'm sure your lordships and your ladyship are familiar with this provision. that section 105 subsection 1 is clear that the term court, including as used in section 70 subsection 8, means the first instance court, the High Court or the County Court. Accordingly, we would suggest that section 70 subsection 8 is in fact an indicator that permission to appeal from a decision in section 70, including subsection 7, is to be decided by the first instance court. My lords, my lady, this point of construction is also supported by and consistent with the point of policy which I wish to address. Section 1 of the Act, which is contained in the same tab that you have open at page 4, is an expression of the policy that the Act seeks to address. It is a familiar point to say that the Act takes as its policy avoiding delay and expense and limiting court intervention in the arbitral process except as provided in Part 1 of the Act. That point of policy is true, no less, in respect of applications for permission to appeal. The questions of principle for which permission is appropriate can readily be identified by the first instance court, and that is why we see the limitation language peppered throughout Part 1. That point was very much the intention of the drafters of the Act. If your lordships and your ladyship can please turn to tab 3 in this first authorities bundle, you will see the well-known report of the Departmental Advisory Committee from February 1996. The relevant paragraph for attention is at page 81 of the bundle and is paragraph 27. You can see there, my lords, my lady, that the DAC stated that the bill used the words "unless the court certifies." These were changed by amendment to "which shall not be given unless the court considers." The DAC then goes on. This amendment was made to make clear that where an appeal is desired from a decision of the court, leave must be obtained from that court itself and will always be required. Leave may not be obtained from the Court of Appeal.
Isn't that by reference to the identified sections?
It is, my lord, but the point that we rely on from paragraph 27 of the DAC report is that it is expressing, in connection with sections 45 and 69, that same policy that one then sees reflected ultimately in section 1 of the Act. So there is a coherence, we would suggest, between the policy expressed in section 1, the articulation of this point in paragraph 27, and what we suggest this court should find in relation to section 69 and section 70, subsection 7. We say that that taken together militates in favour of a construction of the Act that does not add layers of appeal or court involvement where none are stipulated. We respectfully suggest that that is the construction that I took your lordships and your ladyship through at the start of my submission. I come now to the point on authorities. As the court knows, this court has considered what comprised the decision under section 67 and 68 before. I, of course, refer to the NIOC. That is at Authorities Bundle 3, tab 29. I hope I'm not testing the court's patience by asking you to look at that decision.
I'm not testing mine anyway.
The paragraph I wish to start with, my lord, my lady, is paragraph 62, at page 961. There you can see the court statement. There are statements which suggest that a decision, which is part of the process of reaching a final decision on a challenge to an award, is a decision under section 67 or 68 as the case may be. Now, in that judgment, this court went on to hold that a decision under section 73, the provision dealing with the loss of a right to object, is a decision that is part of the process of determining a section 67 or 68 challenge. As the court will recall, the court used various descriptions of a decision that would qualify as being under section 68, to use the word from subsection 4 in that provision. The court referred to a decision that is within the compass of section 67 and 68. You can see that language in paragraph 62. It also used language in paragraph 65 over the page, which is entirely ancillary to section 67 and 68. And also the language has no relevance or application independent of a challenge to an award under one or both of those sections. Pausing there, section 70, subsection 7 meets these descriptions for the reasons I have already given. We suggest that the point of construction and the point of policy militate quite clearly in direction of that conclusion. I said earlier that the present issue before the court is clearer for it to decide than the one in NIOC, and I gave you some reasons for that. But I wish to just extend those submissions slightly now that we have NIOC in front of us. Trying to rival my learned friend for darting back and forth between bundles, can we please also bring up the first authority bundle so we can see section 73 in front of us. It's at page 37 of tab 1.
It's set out in the NIOC judgment for those who don't wish to dart backwards and forwards.
I'm grateful. For those who have, one can see that section 73 is there on page 37. But it is also evident if one turns back a page, so I might be testing your lordship's memory, that this provision appears in a different subpart of part 1 of the Act. It appears in a different subpart to those provisions of section 67 to 69 and section 70. It's only a small point, but it is still a point which highlights that section 73 does not have that same structural or framework connection with section 67 to 69 that section 70 has. And the reasons for that, for locating section 73 in a different subpart, are evident. The scope of operation of section 73 is not limited to applications before the court. It also covers proceedings before the tribunal. By comparison, we say that the case for regarding a decision under section 70, subsection 7, as ancillary to or having no independent application outside the context of a challenge or appeal under section 67 to 69 is even clearer. In the context of that clarity of statutory construction, we respectfully submit that my learned friend's argument is left seeking to apply a gloss to the terms of the Act.
So actually I was wrong in paragraph 65 of NIOC to say that 73 is entirely ancillary to 67 and 68 because it could apply to further proceedings before the tribunal.
No, my lord, you were not wrong.
Right?
The decision in NIOC in relation to section 73 being entirely ancillary to section 67 to 69 is eminently correct. There are a number of reasons for that, which your lordship set out in NIOC and your ladyship as well. But one of those reasons is that section 73, as my learned friend indicated this morning, is contained by cross-reference in section 67, 68 and 69. There are textual links between section 73 and section 67 to 69 that confirm that the decision in NIOC is correct.
I think the point my lord is putting to you, that he's right now, that he was wrong then, is section 73, you've just made the point, is in the subpart-headed miscellaneous because it has potential life outside of a challenge under 67 and 68. It has potential life in relation to proceedings before the tribunal itself. And I think that's the point.
Yes.
Perhaps the word entirely is the rogue word that may not
But of
give
course,
it
in NIOC, the section 73 point arose in the context of
a court challenge.
Exactly so, Your Ladyship. The only life that a Section 73 application can have in the context of proceedings before the court is where there is a Section 67, 68, 69 challenge. And that is the point which underlies NIOC. It is not an incorrect decision, but given that...
I don't think anybody's suggesting it is.
No, quite.
But it's just simply... I think it's a point that you made earlier when you said that your submission is that the result under Section 70, subsection 7 is a fortiori or a stronger case than under Section 73, because you say the link between Section 70, sub 7 is stronger because Section 73 could apply in other circumstances, whereas 70, sub 7 is solely dedicated to applications before the court under Section 67, 68, 69.
Your Lordship has the point. There is an extra element of statutory construction that makes the issue decided today clearer or more straightforward than the slightly more difficult decision.
Well, all I was saying really was that I may have expressed things a little bit loosely, but not in a way which affected the actual decision.
Yeah.
Anyway, I think we've ploughed that ground quite enough.
I think we're in furious agreement. Now, as I was indicating, my lords, my lady, in the context of what we say is the clear position on construction, we suggest that my learned friend's argument is left seeking to apply a gloss to the terms of the Act. Namely, the gloss that the decision has to be tied to the substantive decision-making process for it not to be susceptible to permission to appeal by this court. As your lordships and ladyship have seen, that gloss is not present in the terms of the Act. Now, my learned friend relies on two cases in paragraph 42 of his skeleton. The first is Manchester City. If we could please turn that up. It is in the authorities bundle 3 behind tab 27. As you can see in the head note, immediately following the heading held, and this is drawing from paragraph 40 of the report, this was about whether a judgment should be published based on the application of common law principles. This was not a decision of the court under the Act, that is under section 67, 68. A decision as to the publication of a judgment following the substantive hearing of the challenges, we say is entirely different to a decision as to whether security for the award should be awarded in advance of the hearing of the challenges. While we have Manchester City in front of us, it is also worth recalling the examples of what the court thought would be decisions under section 67, 68. If the court could turn to paragraph 39 on page 908, I'd be grateful. One can see in that paragraph, just below G, that a case management decision about how an application should be conducted, as well as consequential cost decisions, were thought to be decisions under section 67 and 68. Those are not decisions which would necessarily have a bearing on the substantive outcome. But the court, of course, held that they would still necessarily be under those two provisions. This morning there was some discussion about whether there were types of case management decisions that this court would be likely to give permission to appeal for. We say that there are, of course, quite a number. Your Lordship, Lord Justice Mayles, referred in discussion to an application relating to disclosure, maybe with contested issues of privilege. One can readily see that permission to appeal would be granted in relation to that type of case management decision. Others that might arise will be whether to grant permission for an issue to be dealt with as a preliminary issue. Also, a decision not to adjourn a trial if a witness is unavailable or seriously ill. Case management decisions, of course, come in many forms, but we respectfully suggest that it is not difficult to identify categories of case management decisions for which an order for permission to appeal by this court would be appropriate.
Well, I suppose they not only come in a number of forms, but the bearing that they can have on the outcome of the case will also vary enormously. I mean, some case management decisions may have a very direct impact.
I would respectfully agree, Your Ladyship. That type of impact may well be significant delay, as was touched on this morning, but it may be also substantive. The last example that I mentioned was a decision not to adjourn a trial if a witness was not available or seriously ill. We've all been involved in cases where witness evidence is critical. A lead witness may be able to make or break a trial. And so a decision to proceed with a trial where such a witness is not available would have a serious substantive impact and would quite appropriately be the type of thing for which permission to appeal might be sought by the losing party. The second case that my learned friend refers to in paragraph 42 of his skeleton is the case in Sumacan. This is in tab 1 of the authority, bundle 1 of the authority bundle, behind tab 9. The relevant paragraph is paragraph 32 at page 142 of the bundle. As your lordships and your ladyship can see, just below D, this court held that the questions arising on section 70, subsections 2 and 3 were procedural points. That is, whether an applicant had exhausted other avenues and whether the 28 days had expired from the date of the award. They were regarded as being within the compass of the procedure of deciding whether permission should be given, and thus were decisions under section 67 and 68. We respectfully submit that nothing in these findings suggests that a decision as to whether security for the award in section 70, subsection 7 is outside the compass, to use the language here. My lords, my lady, those are our submissions on the Act. Construction, policy, authority. Before leaving jurisdiction, I just want to touch on some of the practicalities of my learned friend's argument. Now, my learned friend says, this is paragraph 42.2 of the skeleton, that a decision on an application for security for the award, and I quote, has no bearing on whether the right to challenge under those sections is lost or retained. We submit that that cannot be correct. I have 2 points here. First, where security for the award is ordered in the context of a section 67 or 68 challenge, it does have the potential to affect that challenge, much in the way that I was just discussing with your ladyship. The starting point we submit on this is what this court has made clear previously. It does not matter whether the security for the award application succeeds or fails. This was a point touched on in NIOC. That is at the authority bundle 3 behind tab 29. But I would like to take the court to the now famous paragraph 65. see in the final third or so of that paragraph the court's observations relevant to this point. There, this court said, decision is a broad term, and the determination of a Section 73 issue is naturally to be regarded as a decision under Section 67 or 68 as a matter of language, whichever way it goes. There is no justification for saying that it is a decision under Section 67 or 68 if the Section 73 issue is decided in favour of the award creditor, but not if it goes against the award creditor. So the court is not engaged in an assessment on a case-by-case basis of what the effect or the positive of a positive or adverse decision on security for the award will be. What matters, I respectfully submit, is the potential for such a decision to affect the challenge. As was noted this morning, the order that the appellants seek includes a provision that, if security is ordered but not provided, the challenge will be dismissed as a whole. Continuing the discussion that we have had this afternoon, I suggest that it is obvious that such an order has a potential to affect the Section 67-68 challenge, indeed to stifle and dispose of it altogether. The second point of practicality I wish to make is that a decision on security for the award must also consider to some extent the merits of the challenge, at least in the context of a Section 67 challenge. Now, I don't believe it is disputed by my learned friend that it is generally accepted that security for the award will be given in a Section 67 challenge where the challenge is flimsy. There was discussion with my learned friend this morning about how necessary that requirement is. I do not understand him to have departed that that is the general position adopted in the authorities to date. Indeed, that was the position that the defendants articulated before the judge below in paragraph 83 of their skeleton there.
Well, that is what the cases say, but it's rather odd, isn't it? Because if the challenge is such that it has no real prospect of success, then it can be kicked out anyway, either with a hearing or pursuant to paragraphs in the Commercial Court Guide without a hearing. So don't need to think about security in those circumstances. And if flimsy means something else, well, what on earth does it mean?
Well, quite, my lord. I don't think it is necessary for today's decision to delineate between a challenge that does not meet the standards set out in the Commercial Court Guide and may be dismissed even without a hearing, and what the content of flimsiness is. However, what your lordship's question, I respectfully suggest, indicates is that an assessment of the merits at that stage of dismissal or when security for the award is sought is relevant. It will not be possible, we respectfully suggest, for a decision on a security for the award to be taken with no regard at all for flimsiness, merits, strength, however one wants to frame it. The reason why this is important,
I mean, on a security for costs application in court litigation, I think you're generally warned against trying to get into questions of the relative merits unless they are very plain. I think I'd have to go back to look at the authorities, but I think you're basically told not to try because you end up having mini trials and getting distracted when that's really not a productive exercise. I mean, why should the position be, as my lord has said, why should the position be any different? I mean, either you strike the thing out because it has no reasonable prospect of success or whatever that test is, or you really can't get involved on this type of application in weighing the merits. It's a slippery slope you start embarking down, isn't it?
I can well see that, my lord. And as to why flimsiness and a need to appreciate the merits in a security for the award application is required, I would suggest that that is consistent with that underlying policy of the Act that we looked at a few moments ago. The type of intervention that security for the award can have, as I've mentioned, is possibly to stifle a claim and dispose of it altogether. In those circumstances, the type of intervention that is possible and contemplated under Section 70, subsection 7, is one of the more dramatic kind available under the Act. So in those circumstances, I submit it is not surprising that the authorities have developed a test when considering security for the award that is different to the test and the caution around mini-trials in security for costs. It is an entirely different type of application between the two. Indeed, below, before Mr. Justice Bright, the defendants made both types of applications. Security for costs was in the order of around £4 million, but security for the award was in the several £100 million. So in this case, it is an acute example that demonstrates the justifiable difference between a test under security for costs and a test under security for the award. The court will recall, as my learned friend took you to this morning, the decision in progress. Now please trouble the court to go back to Authority Bundle 2 at tab 19. The decision in progress starts at page 505 of the bundle.
Just thinking about the point you've just made, it might rather suggest that a sort of default 1 hour for these sorts of hearings would not be appropriate, because effectively what you're saying is the merits should to some extent be scrutinised.
Your Ladyship anticipates,
Yeah.
Your Ladyship anticipates a point I was going to come to later in my submission. But that we would suggest is an indicator of the caution and the need for a test as developed in the authorities when it comes to an application for security for the award. That's my short response, but we will come back to exactly that point around the operation of the Commercial Court Guide and the rules.
The point may be the other way around, that if you can't do it in an hour or so, then you shouldn't be doing it at all. And that rather suggests that you don't get into the merits, because there's no point in trying the case twice, once on security and once on the substantive challenge.
And in the authorities discussing flimsiness, there is an awareness of exactly this issue, my lord. And that awareness is reflected in the fact that those authorities do not conduct a mini-trial, but they talk about flimsiness in a manner whereby it is evident that the case reaches that standard. It is not a final decision on the merits, of course, but rather a suggestion that the challenge is indeed flimsy and therefore the power under section 70, subsection 7 may be available. In the progress decision, my lords, my ladies, paragraph 50 is the relevant paragraph, which is at page 520. My learned friend took you to this morning. There you can see at paragraph 50, Mr. Justice Pickham sets out that in the case of an application under section 67 of the 1996 Act, there are 2 requirements which would generally need to be met for the exercise of the power under section 70, subsection 7, namely flimsiness, prejudice. My learned friend also said that security for the award could be ordered by reference to the facts of the case. In his skeleton before Mr. Justice Bright, the position was stated that in an exceptional case such as the present, that power should be exercised on a principled basis on the facts of the case. We've heard a similar submission today. But whichever way one approaches it, the defendants argued in some detail before the judge about the weakness of the claimant's challenge. Flimsiness is now not maintained as a ground of appeal before your lordships and your ladyship, but I do just want to show you how detailed a factual assessment Mr. Justice Bright was invited to undertake. Could we please turn up the defendant's skeleton before the judge, which is in supplemental bundle 2 behind tab 10. page in the bundle starts at page 105.
So what exactly is the point of what we're about to embark upon, bearing in mind the way you introduced it?
Yes, my lord. The point that I wish to take you to see that there is not a flimsy objection before the court below, is that ultimately...
But given there's no appeal on that point, I'm just trying to understand why we're being asked to look at it.
I would wish the court to see the nature of, or the extent of the submissions that were made by my learned friend on flimsiness.
Well, I get that, but why?
So I can then take the court to draw out what we say is the submission before you. And that submission is that there is a division or a categorization of decisions that my learned friend says are appropriate and susceptible to permission to appeal, and those that are not. The point that I'm taking your lordships and your ladyships through now is a very brief one, simply to say that on page 106, over the page from the start of the tab, that the largest part of my learned friend's submissions before Mr. Justice Bright relate to flimsiness. And the point I'm making, my lords and my ladies, is that on my learned friend's case, a decision must be taken on the facts relating to the Section 67 challenge. That necessarily involves a decision by reference to the legal standards under Section 67, even if only on a provisional basis. So whether one applies the flimsiness test set out in Progas and other cases, or whether one adopts my learned friend's approach of consulting the facts in a more general manner, the court will, to some extent, have to take the merits of the challenge into account. And when it does so, necessarily that will need to be by reference to the legal standards in Section 67. That's all I wish to say, my lords, my lady, as to the 2 points on the practicalities, which we say illustrate that my learned friend's argument that a decision under Section 70, subsection 7, is dissociated from the decision-making under Section 67. Coming on to what I indicate to your lordship, Lord Justice Snowden, I do want to draw out now a little more of what we say my learned friend is putting to the court. My learned friend is suggesting that there are different categories of decisions once the jurisdiction of the court has been engaged. The first category is applications which result in a clear-cut answer to whether the right to challenge is lost or its scope is constrained. That is how my learned friend puts it in paragraph 42.2 of his skeleton. But necessarily, therefore, another category is applications which do not produce clear-cut answers, even if they have the potential to cause the right to challenge to be lost or its scope constrained, such that, while the right still exists in theory, in reality it becomes an empty or lesser right. The example before your lordships and your ladyship in these proceedings in relation to security for the award, in respect of which a claimant then does not pay security or is not able to pay the security, is an example. My learned friend's argument would have it that permission to appeal cannot be granted by this court in relation to the first of these categories, one relating to clear-cut decisions, but can be granted in relation to the second category. Whichever way one looks, we submit that that is an artificial distinction. There is no basis in Section 67, subsection 4, and its analogue in Section 68, for such a distinction. It is this type of taxonomy of which this court has been wary in the past. I refer again to the decision in NIOC. Your lordships and your ladyship may wish to turn it up, but I can also simply read to you that the relevant text from paragraph 66 is the text referring to the paradox that arose in that case. It would be paradoxical to interpret those provisions to mean that only the first instance court can grant permission on the final decision to uphold or dismiss the challenge to an award, but that the Court of Appeal can give permission on preliminary or case management decisions when the first instance court has refused such permission. In that instance, this court was considering the distinction between final decisions in a challenge and a decision on preliminary or case management matters. Here, the distinction between different categories of decisions that my learned friend is asking you to draw involves a further degree of taxonomy, being a distinction between orders that have an impact on whether the right to challenge under those sections is lost or retained, or orders that do not have such an impact, even if they have the potential to do so. The paradox here we suggest of such a distinction would be even more acute than the paradox identified in NIOC. Namely, it would be paradoxical to interpret section 67 subsection 4 and its analogue in section 68 so that only the first instance court can grant permission on final judgments and on orders that produce clear-cut answers to whether a right to challenge is lost or its scope is constrained, while this court can grant permission on orders that have the potential, but not the certainty, to cause the right to challenge to be lost or its scope constrained. We submit that there is no need for such distinctions or categorizations. It generates confusion and contention. It would generate more applications for permission, seeking to fit into the right categorization, and thus draw the courts even more into the arbitration process. My lords, my lady, that is what I wish to say on jurisdiction. I turn now to address the conditionality with which we say any permission to appeal ought to be granted. I start with a point that was made by my learned friend this morning, even if briefly, where he said, we are here now, such that imposing a condition is all too late. True, of course, it is that we are here now. But the point of a condition, unlike, for example, an order for security for costs, is not to secure us as a party or the Czech Republic as a party. Rather, it is to condition the permission that is granted for the moving party to be able to approach this court. So with respect, I would suggest that my learned friend's point on that, though brief, does not take the matter forward. As to my learned friend's undertaking that was offered this morning, the Czech Republic accepts that undertaking, and that therefore means the second condition set out in the respondent's note has been resolved. It is not advanced. The first condition, however, I submit remains and ought to be ordered. As the court heard this morning, the defendants are in breach of a cost order of the English court since 2019. That was an order to pay the Czech Republic's costs in relation to enforcement proceedings that the defendants brought in English courts in respect of the 2008 commercial arbitration award. It's worth just looking at that order in order to see what is in issue. It's in Supplementary Bundle 2, behind tab 4, at page 63. If one turns over the page to page 64, the relevant paragraph is paragraph 5. Pardon me, I misspoke before, my lords, my lady. The order is from October 2018, not 2019. You can see there at paragraph 5, the order is set out by Mr. Justice Blair for the third party, which is a reference to Mr. Sava, to pay certain sums, which then were just over £1 million, but today are just over £1.4 million, by 4 p.m. on the 26th of October 2018. It's not disputed that that order has not been paid. My learned friend this morning referred to an offer of a guarantee that has been made. But with respect, we submit that that is nowhere near enough. This is an order of an English court that has not been satisfied for now more than 5 years, and the guarantee is not sufficient. in terms of authorities around the action that we suggest this court should take, Cruise City, in the first bundle of the authorities at tab 13, is apposite. The relevant paragraphs are at 36 to 37 at page 223 of the bundle. I'm afraid that paragraph 36 is a very long paragraph, but the relevant part of it is on page 224. About a quarter of the way down, the sentence begins, if in circumstances where there is no longer any challenge. You can see that towards the right of the page. Lady Justice Gloucester continues. If in circumstances where there is no longer any challenge to the arbitral award or liability judgment, a judgment debtor wishes to invoke the appeal procedures of the English court and to seek permission to challenge enforcement orders adverse to its interest, it cannot, in my judgment, at the same time, lightly cock a snook at other English court orders requiring it to pay the award or judgment debt. That, in my judgment, provides a compelling reason why an appellant, in the position of the appellants in this case, that case, should be required as a condition of exercising its appellate rights to pay the judgment debt into court. And then if your lordships and your ladyship go to the very bottom of the same page, 224, in the final line, you can pick up the language, the fact that the imposition of conditions, continuing from there, seeks to ensure compliance with earlier liability judgments or orders, which are not themselves the subject matter of the current appeal, in respect of which permission is sought, is irrelevant. Nor is there anything in Mr. Hurst's point that in the present case, the relevant awards and orders were technically made in separate proceedings. Circumstances similar to those here. Lady Justice Gloucester continues, in my judgment, there is nothing unjust or inconsistent with the overriding objective in requiring the appellants to comply with those awards and court orders as a precondition for the prosecution of any appeal.
What are you suggesting we should actually do as a matter of practicality? Because I had envisaged that we would simply give a judgment, but are you suggesting we should somehow do it in stages, so that first of all we give a judgment about whether we have jurisdiction, and then if we do, whether we would give conditional permission but not actually decide the substantive appeal until we know whether this order is going to be paid, because we're sort of running out of time for this sort of thing. The hearing is sometime in January?
At the very end of January, my lord. The way that your lordship indicates the court could move forward is of course available to it. But as to the practicalities, the submission that the Czech Republic was planning to make is that the defendants, the appellants, ought to make the payment and provide that payment within 14 days of today. Failing which, the appeal is dismissed, and only after which the court will issue any judgment, whether on jurisdiction, permission, or the appeal. Well, I defer to your lordship, of course. I would respectfully submit that that may be a simpler way to move forward. The point that we rely on as a matter...
That takes us to the very last day of term.
It does, my lord. The 21st of December. Indeed, if the intention of the court, and I of course would not want to presume, might be for judgment to be issued during this term, then that period of time for 14 days could be shortened to 12 or 10 days. But the simplicity of the practicality that I'm trying to suggest is that the costs ought to be paid. And when it's paid, the court will then issue its judgment. We say that that is the appropriate way forward, because as Lady Justice Gloucester indicated, it's not appropriate for a party to take advantage of the machinery that the Act makes available to them without themselves complying with a substantial and long-standing order of the court.
Anything more on permission and conditionality?
There is just one very short point, I'm afraid, my lord, which responds to something my learned friend mentioned this morning. It relates to that cost order which remains unpaid. My learned friend suggested that that cost order was made on the basis that Mr. Stava controlled Diag Human, that D2 controlled D1, and that that was the position adopted by the Czech Republic before Mr. Justice Blair. My learned friend then pointed out that now, as a basis of one of the challenges that the Czech Republic puts forward under Section 67, we say that Mr. Stava does not control Diag Human. Now, the defendants have raised this point before, but I respectfully submit it is an incomplete picture. It has been dealt with by the Czech Republic in the evidence in these proceedings. I'm afraid I do need to take you to it. It's in Supplementary Bundle 2, behind tab 12. This document is the 6th witness statement of Ms. Mallory. And the relevant page in the bundle is page 206. The relevant paragraphs are paragraphs 33 to 35. In the interest of time, I might simply ask your lordships and your ladyship to cast your eyes through those paragraphs.
I'm probably missing something really basic. The order, the outstanding order for costs is against Mr. Stava personally. The parties to these proceedings do not include Mr. Stava, and indeed you say he doesn't. Your position is that he doesn't control.
Mr. Stava is the second defendant in these proceedings, and therefore the second appellant before this court. And so the same two parties that are before the court at the moment and were before Mr. Justice Bright are the two parties that are discussed in Mr. Justice Blair's order. While it was Diag Human that was party to that proceeding before Mr. Justice Blair, it was Mr. Stava who was the third party in those proceedings.
Okay, so Mr. Stava is an active party in this appeal? All right, okay, thank you.
My lords, my lady, that is all I wish to say on conditionality of any permission.
Right.
Unless your lordship wish to address any point arising out of that, I'm just looking at one of the most important people in the room to see whether or not now might be appropriate for a short break.
Well, we will take 5 minutes now. No more than that.
All rise, if able.
Yes.
My lord, my lady, I come to the appeal. I wish to deal with 4 points that I submit are key points, before then coming to make some discrete points in relation to my learned friend's grounds of appeal. The first of the 4 points is this. To succeed, my learned friend needs to persuade you that it would be right not to apply either of the existing requirements for the grant of a Section 70, subsection 70, order for security for the award. In a Section 67 challenge, there are generally 2 requirements to be met. The first is that the applicant must persuade the court that the challenge is flimsy or otherwise lacks substance. And the second is that the applicant must show that the challenge prejudices his ability to enforce the award. It is not disputed between the parties that that is what is generally required. The judge also accepted this. Could we please turn to the judgment in Core Bundle 2, tab 9, at page 84. Paragraph 60 and 61 on page 83 are the relevant paragraphs. And you can see there that Mr. Justice Bright makes those points about what are generally required. First, flimsiness, second, prejudice. Now, my learned friend has advanced no appeal on the basis that the judge's findings on flimsiness were wrong and that my client's case is flimsy. Likewise, my learned friend does not contend that the challenge prejudices the ability to enforce or honour the award. Neither of those propositions are contained in the grounds for appeal. Those 2 requirements are the points generally to be taken into account when considering an application for security for the award. But the appellants do not seek to satisfy either of them. My learned friend therefore needs to convince you that security for the award can and will be ordered despite not addressing either flimsiness or prejudice. I suggest that that is a high hurdle to overcome. I'll come back to some of the cases on flimsiness and prejudice in a moment. The second key point that I wish to start my submissions on the appeal with is as follows. Even if one were to think that the judge erred in law, the court would need to think that security should be ordered if a different approach were taken to the law in order for the appeal to succeed. We suggest that that is not a realistic proposition, and I make 2 points. The first is that there is a non-flimsy jurisdictional challenge advanced by my client. I appreciate that this will not have been the focus of your lordships and your ladyship, but I do want to show you an example of the type of objection that we are talking about. And the reason I do so is not to convince you here and today that this is an objection that is going to succeed or not. The reason I do so is because in our submission, flimsiness will always be a requirement. Whether you establish it as part of a test or it is simply a consideration that realistically will always be taken into account, whatever approach on the law one adopts, flimsiness is going to be part of that approach. in those circumstances,
I'm sorry, I'm not really understanding this. I mean, either your challenge is so hopeless, as my lord said, it in fact could just be struck out, or the court will assume that the challenge has some viability, enough to get to the second question, which is risk of prejudice. I mean, unless you could say, as it were, your challenge is so good, so obviously good on its face, that you shouldn't be required to put any money up at all, which is the other extreme of this spectrum. Why do you say the flimsiness, whatever that rather odd expression means, should come into the balance at all? Because all it does is invite the court to start down a path it probably doesn't want to go down.
indeed, my lord, and the reason flimsiness is part of the analysis in a security for the award application is because when that application is made, the court will need to assess to some extent whether the objection has some meat to it. That's been a consistent, a golden thread through the authorities to date. So in those circumstances, while prejudice...
But why under the separate heading of flimsiness?
My lord, the separate heading for flimsiness in the authorities, I would say, derives from the fact that when you are being asked to order payment in of the entirety of the award, that is not appropriate if a viable Section 67 challenge is made. In those circumstances, where there is no presumption of validity or correctness of the findings of the award, that is why such a...
But if you put it in terms of viability, then I understand the point, because you either say it's not viable, in which case strike it out, or if it is viable, move on to step two. But so in other words, if all you're doing effectively is applying the reverse strikeout test, then I'm not so troubled by it, but it's this idea that there's a freestanding flimsiness test floating around somewhere. Is that what you're saying?
Well, that's drawn from the authorities, my lord. And perhaps the difference is a procedural one, in the sense that an application for strikeout may not be made. It may be that a defendant regards the application as not so lacking in merit that there are no prospects of success and a strikeout will occur. However, that is a slightly different question to whether or not that type of objection would be regarded as flimsy. One can see that there is a difference between those two standards. And so a defendant might choose as its procedure, not a strikeout application, but instead an application under Section 70, subsection 7. A defendant might reasonably say, I don't think I'm going to convince the court that this should be struck out entirely, but I do think I can convince the court that the application and the challenge is so weak that it is flimsy, and therefore security for the award should be paid.
But then you're using the happenstance of somebody wishing to challenge the award as a vehicle to get enforcement by the back door, if I can put it that way.
Well, my lord, we certainly make the point that there are issues in relation to when a defendant can seek security for the award in proceedings under a Section 67 or 68 challenge, as compared to what rights they might have if they seek enforcement of the award. That's a separate point that we'll come to later. But you're right that there is a degree of involvement of happenstance, and an example is the state immunity point that I will turn to. But simply because that happenstance is an active part of the procedural decision-making of a defendant, we say does not undermine the test laid out by the authorities, which include these two considerations of flimsiness and prejudice.
Don't the terms of the section itself suggest that the merits and flimsiness have really got nothing to do with it, because they apply equally to applications under Section 69, where ex hypothesi there is a strong case, because you only go under Section 69 if the award is obviously wrong, or if the case is one of more general importance and it's open to serious question. But even in those circumstances, there is the jurisdiction under Section 70, subsection 7. So that suggests, to my mind at any rate, that this whole debate about whether challenges are flimsy or not is barking up the wrong tree.
And it just creates, to add to my Lord's point, it just creates the very issue about when somebody tries to challenge under both that was sort of identified in those paragraphs that you're looking at. You know, why does the judge have to go through that sort of contortion?
So, my Lords, I might take my Lord Justice Mayall's question first, and then come on to my Lord Justice Hensford. My Lord Justice Mayall's, to the extent that flimsiness is being suggested as a hard and fast rule, as the authorities have referred to, as my learned friend adverted to this morning, I can understand the position that minds may differ as to whether it is a hard and fast requirement or not. But I don't need to put my case that high to succeed. Rather, what I need to suggest is that flimsiness, or some review and consideration of the merits of the challenge, will be a relevant consideration for any exercise of the jurisdiction under Section 70, subsection 7. So to the extent that it might be regarded as barking up the wrong tree to regard flimsiness as a sine qua non, I appreciate that minds can differ in relation to that. And that is much of the argument between myself and my learned friend. But the issue isn't so much whether or not it is a hard and fast requirement, but rather whether, on any legal formulation, one will consider the flimsiness or the content of the objection to some extent. And in my submission, an order for security for the award, which takes no account of the content of the objection, does not look at their merits or their strengths at all, would not be an appropriate way to formulate the test. Indeed, if there is to be an alteration of the test set out in Progress and the other authorities, I would not suggest it's appropriate for flimsiness to disappear or be disregarded altogether. A proper appreciation of the type of objection is a necessary component in the suite of considerations under Section 70, subsection 7.
Well, isn't it rather like what Lord Justice Stoughton had in mind in the Soleil-Bonnet case, which is that you have what he calls a brief consideration, no more than that. If the challenge is manifestly valid, well, of course you're not going to order security. If it's manifestly invalid, then you're going to chuck it out.
And Lord Justice...
And that suggests to me that the merits are pretty much irrelevant under Section 70, subsection 7. I appreciate Soleil-Bonnet was not a Section 70 case, it was a New York Convention point, but similar considerations. What the section is concerned with, seems to me, is what the DAC said it was concerned with, which was nothing to do with the merits of the challenge.
But prejudice.
Yeah.
I can well understand that, my lord. And I think why the authorities have been insistent and have created this golden thread of flimsiness is that were the decision to come down to...
Flimsy golden thread.
There are multiple golden threads, perhaps.
Perhaps it's time somebody snapped it.
It's flimsy anyway.
Well, to put the point as high as I can, my lord, the reason why the authorities focus on this is that if it were prejudice alone that were relevant and taken into consideration, and there was no regard paid to flimsiness or the content of the objections at all, then in those circumstances, the type of objection that could be advanced would be without limitation when it comes to a consideration whether security for the award is appropriate. So for that reason, I would suggest that flimsiness is a required part of the consideration. There's a debate to be had about whether it's a hard and fast...
I don't understand why that works that way. The defendant comes to court and says, please make an order that security for the award, because this is a really terrible challenge. And, you know, the judge wrote in a robust way says, well, if you thought it was a rubbish challenge, why haven't you applied to strike it out? Mm. You know, it's a good old sort of county court judge approach to litigation. But there's a certain amount of sort of merit in that, isn't there? What? And then if you haven't applied to strike it out, Mr. Defendant, then let's move on to the next question. You know, I'm not sure why you're arguing so fiercely in defence of the flimsiness requirement. It sort of seems, to be honest, I mean, I don't know what you've got going on in other cases, but you know, why wouldn't it suit you to just say, look, this is all about whether they can show that you're doing something which may well prejudice the enforcement of the award.
Well, and this is rather the point that I was developing, my lord, that whichever way one formulates the test, whether that is with flimsiness and prejudice as two requirements, or two considerations amongst others, or indeed even if one does drop flimsiness out of the consideration, whichever way that test is formulated, there is no basis on which we say the appellants can satisfy that test. And so as a result of that, however the court might consider formulating the test, that does not change the ultimate outcome that Mr. Justice Bright reached. It would not be an appeal that results in the appeal being granted. The appeal would still be dismissed, even if your lordship's and your ladyship reasons might differ from those of Mr. Justice Bright. And so that really is the second of these leading points that I wish to make in relation to the appeal, which is that whichever way the test is formulated, whether that is by reference to flimsiness and prejudice or some other combination, as my learned friend has encouraged, it is not the outcome that the appeal does succeed.
Right. Well, as you're only on the second of your preliminary points, we better be quiet for a while. Let you
No, of course, my
develop
lord.
your suggestions.
I echo my learned friend this morning saying that I certainly welcome interventions in order to see how I can. I would only note in relation to the discussion that we've had, my lords and my lady, that of course that test and the endorsement of flimsiness is not just referred to in first instance authority. In addition, as you'll recall, Lord Mance in the IPCO decision, which is in the authorities bundle, also addressed this point. I believe it's authorities bundle number 2 at tab 17. That begins at page 472 of the bundle, but the relevant paragraph is paragraph 43 at page 488. Beginning just above G, you can see that His Lordship is giving a number of reasons in relation to an argument that has been put by Mr. Black, QC. And it's the fourth reason that drew its attention. There, His Lordship says.
It's almost certainly not ratio, is it?
Pardon me, my lord.
It's almost certainly not ratio in a
I
paragraph
don't
beginning
suggest it is.
with the words in any event.
Yes, I don't suggest that it is, only that this point has received judicial consideration at the highest level. So in a consideration as to the appropriate formulation of the test and the role of flimsiness in particular in it, we suggest that that is a relevant finding. Indeed, even if one does not consider flimsiness as an absolute rule, we would suggest that the fact that a Section 67 claimant has made a serious jurisdictional challenge is a factor carrying significant weight when considering whether to order security for the award. And that is why, my lords, I just want to spend a little bit of time looking at an example of one of the challenges that the Czech Republic has made. Not to persuade you today that it will succeed or not, or whether it meets a flimsiness test or not, but rather to indicate to you the substantial nature of the challenge that is before the court below. Could we please go to supplementary bundle number 2 at tab 11. This is our skeleton below before the judge.
Is this the point that Diag Human and Mr. Strava had ceased to be investors?
So it is the point, my lord, that in mid-2011 in June, Mr. Stava disposed of his...
Put the shares into a discretionary trust.
Exactly, my lord.
Therefore not his anymore, therefore he's not an investor and not controlled by a Swiss person.
Exactly.
That's the point. Isn't it?
If you have the point, I don't need to take you through the material.
Well, if that's all it shows, then I've got the point, and I'm sure my colleagues have as well.
Very good. And the reason that I draw that to the court's attention is that I say, and not just in an example of advocate zeal, that is a substantial challenge under Section 67. In investment arbitration, when an investor alienates from him or herself the investment, that means that coverage under the investment treaty ceases. One cannot be an investor and have an investment and therefore seek coverage of the treaty if it has been alienated from his possession and control. Here we say that that is exactly what happened in June 2011. The point has been very actively and energetically in dispute between the parties. There have been witness statements touching on the point. There have been Liechtenstein law expert reports touching on the point. So in those circumstances, we suggest that it is a significant, a substantial challenge, and which is relevant to understanding whether or not this type of challenge is one which would be appropriate for security for the award to the court. So it's only a short point in the end.
And it was a point, I think, also made in the arbitration, which the arbitrators dealt with over hundreds of pages, or maybe tens of pages, but it was dealt with there.
Yes.
Okay, well, I think we understand that.
Can I just go back one very, very briefly, just to understand why, just by reference to Lord Mann's, you say no security for the award can ever be made unless it's shown that the challenge is flimsy. So if you have a challenge which is not flimsy but not guaranteed to succeed, i.e. can't be struck out, what, you have carte blanche to do whatever you want to do to prejudice the enforcement of an award, secure in the knowledge you can never have security for the award ordered by the court.
My Lord, on the test as formulated by Lord Mann, flimsiness is a necessary part. But in those situations that you're referring to, whereby a claimant may still take some sort of action in order to prejudice the ultimate enforceability of the award, that is of course going to be relevant to an assessment for security for the award and security for costs.
Why? Because if the challenge isn't flimsy, if the challenge isn't flimsy on that test, Section 77 can never be used, no matter how much you do to try and make sure the award can't be enforced.
In relation to a Section 67 objection, my Lord, that would be correct to the extent that flimsiness cannot be proven by the defendant. So if the defendant is not able to say that the objection is flimsy, then security for the award would not be the appropriate relief. Even if a defendant is able to say that there is prejudice that is caused by other conduct of a claimant, this mechanism through Section 70, subsection 7, would not be the appropriate forum for relief. There may be other types of orders that the court could make in order to gainsay or limit that type of misconduct by an arbitration claimant, by a Section 67 claimant. But it is correct that the jurisdiction under Section 70, subsection 7, would not be available in those circumstances if the formulation of the test by Lord Mann's is the one applicable. The last point I wish to make in relation to this second opening point is something that arises.
Sorry, just for me, what other types of orders are you talking about?
So in those circumstances requiring the arbitration claimant, the claimant under Section 67 to make an undertaking may be appropriate. It may be that a form of security for costs would be appropriate by reference to the justice of the case as a whole, including, for example, consideration of prejudice. There may be other orders, my Lord, but those would be two examples that the court would have available to it in order to limit that type of misconduct. My lords, my lady, there's one point arising out of the discussion with my learned friend this morning relevant to this that I just wish to touch on. My learned friend says that even if one applies the existing test, one can still infer that the Czech Republic will refuse to engage with and will avoid enforcement. I just need to touch on this, my lords, my lady, because there is strictly no evidence in these proceedings that the Czech Republic is seeking to avoid enforcement of the award. Indeed, the evidence is to the contrary. The court will recall that there was a 2002 partial award that preceded the 2008 award in the commercial arbitration. That 2002 partial award ordered the Czech Republic to pay some $11.6 million to the defendants. That sum was paid. In addition, there are no outstanding cost orders binding on the Czech Republic from the various enforcement proceedings that the defendants have undertaken in relation to the 2008 award across various jurisdictions. There is also no evidence put forward by the defendants in these proceedings of any difficulty of enforcing the 2022 award in the Czech Republic. There is no evidence from the defendants that it is not possible to enforce the award there. They have not started enforcement in the Czech Republic. The defendants tried below to say that one could infer from the Czech Republic's conduct in the Luxembourg enforcement proceedings that it will not be possible to enforce against the Czech Republic. Mr. Justice Bright heard that point, but there's been no appeal from his judgment in relation to it. So I say with respect that my learned friend's submission this morning that one can infer from conduct in the Luxembourg proceedings that the Czech Republic will seek to avoid enforcement really does not get off the ground. The third point that I want to deal with at the outset of submissions on appeal is that there is a significant factor militating, we say, against an order of security for the award. And that factor is that such an order would in effect circumvent state immunity from the jurisdiction and enforcement proceedings before this court, which the Czech Republic as a state enjoys under Section 1 and Section 13 of the State Immunity Act. My lords, my lady, if the defendants sought to enforce this award in England, they would have to show that Section 1, subsection 1 of the State Immunity Act did not apply. That's a provision that establishes a state's adjudicative immunity. The defendants would therefore rely on Section 9 of the State Immunity Act as an exception to that immunity in order to contend that the Czech Republic had no immunity because it had agreed to arbitration. However, were the defendants to do so, the question whether the Czech Republic had agreed to arbitrate under Section 9 raises the same issues that arise in its Section 67 challenge. This was a point addressed in Tatneft, which is in Authorities Bundle number 2, behind tab 20. I'd be grateful if your lordship and ladyship can turn that up. It begins on page 533 of the book. The headnote is probably sufficient for our purposes today, but you can see at E and F, the headnote shows that Tatneft was relying on the Section 9 exception in the State Immunity Act in the context of enforcement proceedings. It begins with the words on the right, the defendant applied. But if one reads on to the first holding after held, one sees that Mr. Justice Butcher concluded that when a court was considering Sections 1 and 9 of the State Immunity Act and whether it had jurisdiction over a foreign state, it was obliged to consider any issue relating to whether the state had agreed in writing to submit the relevant dispute to arbitration, whether that issue was one apparent to the court of its own motion or was one raised by the state. It could only exercise jurisdiction over the state if satisfied that Section 9 exception was applicable. This is the point developed at paragraphs 55 to 56 of the judgment. Accordingly, the defendants could not enforce the 2022 award unless and until the court held there was no immunity from jurisdiction. That is, that the Czech Republic had agreed to arbitration for the purposes of Section 9. there could be no adjudicative power of the court, and hence no enforcement, until the points raised in my client's Section 67 challenge are determined adversely to it. In my submission, to grant security to the award in these proceedings would circumvent this position. The defendant's point in their skeleton at 59.1 is that the Czech Republic has submitted to jurisdiction in respect of the challenge. But that is irrelevant to this argument. Given the caution that the courts exercise when taking jurisdiction over foreign state defendants, we suggest that this would count against an order of security for the award. It's only a small point, my lords and my lady, but it's one that has not been picked up in oral submissions today, so I did want to touch on it. Fourth point. My learned friend relies heavily on the note. We heard this morning a clear, what I would characterise as concession, where my learned friend says, if we don't get home on the note and what it shows, I can't make the submission. That is the centrality of this document, to this appeal and any prospective order for security for the award. There are a number of difficulties, we say, with this approach.
Just before we do, what did the judge say about the State Immunity Act point, or was he not addressed on it?
Given, my lord, that in the end, the security for your award submissions, and I mean this as no criticism, only occupied 9 minutes of the defendant's submissions, it was sufficient to make short submissions that did not touch on the state immunity point orally before Mr. Justice Bright. The point was contained in the written skeletons, but in the end it was not the subject of discussion at the hearing or indeed in the judgment. So the first difficulty I suggest with my learned friend's position is that the note does not justify ordering security for the award. The alleged misconduct occurred in a different arbitration, which is not the subject of the challenge before the court. And as my learned friend repeated a number of times, the current award, if it is valid, is the remedy for the matters complained of in the note. That is not, we say, a factor in favour of security for the award. Rather, what that suggests is that currently the defendants have an award in their favour which accounts for the very complaint that they advance as a reason for further security for the award. That is not, we say, an appropriate basis on which to provide a defendant with that additional form of protection. The second difficulty is that we submit, and I do not resile from this, that the defendants cannot rely on the note. It is not properly in evidence. The tribunal's findings in relation to it are not binding, and its meaning is contested between the parties. I wish to start with the judge's judgment. If we could please go back to Core Bundle 2, tab 9. The relevant paragraph is paragraph 43 at page 76 of the bundle. You can see that Mr. Justice Bright says this particular document was the high point of this part of Mr. Rishi KC's submissions. However, even this does not go far enough in the context of an interlocutory hearing where the note, let alone many other points that were broached with me much more elliptically, was not fully explored in submissions, let alone on the evidence. Read on a further sentence, and in the sentence after that, the judge says, the BIT tribunal were able to come to firm conclusions about all this. I am not able merely to adopt their conclusions because they are subject to the claimant's challenges. So the judge was clear that the note was not explored in evidence in these proceedings and that he is not bound by the tribunal's findings. I submit that this is a significant point, my lords and my ladies. The defendants did not advance a case on the note in the way it was ultimately put until their skeleton before the judge. We say that it is unfair and causes prejudice for a case to be put so differently at the hearing. Now, my learned friend has made arguments on this in his skeleton and then again this morning, and I want to go through some of them. One of those arguments was that the claimant did not object below to the defendant's use of the note in this way. With respect, we did. If we can please go to supplementary bundle 2.
Sorry, can I just be clear? What do you? Is this a respondent's notice point or something? What? I mean, you're saying that the judge. What the judge? It would have been. I don't know that it would have been unfair for the judge to have taken it into account, brackets, which he didn't.
So it is in the respondent's notice, my lord. You are correct about that. And the point is that where it is suggested that evidence underlying a tribunal's findings are the basis on which security for the award will be ordered, that needs to be squarely put in the evidence in support of that application for security for the award. I will take you through the documents, my lord, but it was not put in that way prior to the skeleton and the arguments before the judge. Indeed, it was squarely put by the defendants that they were relying on the findings of the tribunal, and that is, of course, perfectly appropriate. What is not appropriate is to suggest that evidence before the tribunal, but not then put in evidence in these proceedings as a primary basis on which the application for security will be decided, then becomes the main point. Indeed, your lordship, Mr. Lord Justice Mayers, said this morning that that is now the tree that we are discussing compared to the forest that was before the judge. We submit that this is not a fair process whereby the Czech Republic, having engaged in significant rounds of evidence, then see in the written skeleton shortly before the hearing before Mr. Justice Bright that the note is in fact the main pillar of my learned friend's application for security. Had the point been put squarely in evidence, then of course the Czech Republic would have put in quite different evidence. It would have known the case before it and therefore reacted accordingly. Can we please turn to our skeleton before the judge, just to see how this point arose. This is in Supplementary Bundle 2, tab 11. The skeleton starts at page 151, but the relevant passage is on page 172. Paragraph 20 is the relevant paragraph. And 21. Yes, and I'll take you to paragraph 21, my learned friend is right to know. In paragraph 20, you can see that before the judge, the claimant was very clear, starting in the third sentence. As claimant is set out in its main skeleton above, the tribunal's findings cannot be relied upon in respect of these applications, giving the pending jurisdictional challenge. Defendants' evidence in support of this application was presented on the basis that these were facts found by the tribunal, not, rightly, seeking to establish them by way of evidence as facts for the purpose of this application. While we're here, my lord, my learned friend has mentioned that paragraph 21 is relevant as well. That relates to how the point arose and then disappeared in the arbitration. You might want to take a moment to read that, but we will come back. I wish to turn next to the evidence that the defendants did put in to make good my point that this was not before his lordship until the written skeleton. My learned friend this morning took you to the evidence of Ms. Walsh. It's behind tab 2 in the same bundle, supplementary bundle 2. This is the second statement of Ms. Walsh. My learned friend took you to page 36, if we could turn to that. My learned friend focused on paragraph E, Roman 2 on page 36, which refers to the attempts by claimant to influence the arbitrators and create a form of pressure. But if one looks back to the opening words of paragraph 39 on the previous page, which is sometimes called the chateau, you can see that Ms. Walsh is very clear, and rightly, summarising what the tribunal's findings were. So paragraph 39 begins, the AT, short for arbitral tribunal, has rendered a damning verdict on claimant's conduct of the state, which is relevant to this court's consideration whether or not to grant security for the award. So that was the basis on which it was put. Ms. Walsh's evidence was relying on the tribunal's findings. It was not evidence that these matters that are reflected in the note did happen, or happened in a certain way, or had a primary evidentiary role before the judge. Now, the defendants cannot be surprised that the Czech Republic is taking this position and taking it strongly. Can we please turn to the second witness statement of Ms. Mallory, solicitor for the Czech Republic, which is in the next tab, tab 3. The relevant passage is at page 51 of the bundle, paragraph 29. It is the penultimate sentence in the chapeau to paragraph 29 on page 51. It begins there. The Czech Republic does not agree with the findings the tribunal made in this regard, which is a reference to the inappropriate and corrupt conduct, and asserts in its arbitration claim that the tribunal did not have jurisdiction. That very clearly engages with the evidence of Ms. Walsh on the basis that it is the findings of the tribunal that are in issue. I pause here for a moment to deal with another point that my learned friend made this morning, which is again an important one. He said this morning the Czech Republic has never explained why it has not addressed this point in its evidence. Well, it wasn't put in evidence by the defendants. We've just seen the way in which the evidence of the defendants was focused on the findings of the tribunal, which in a Section 67 application do not have presumptive validity. Indeed, the point was taken on security for the award in its entirety in 9 minutes before the judge below. In those circumstances, the notion that the Czech Republic would put evidence in response to evidence not put forward by the defendants, or would address it orally when barely 9 minutes were given to it at the hearing, is, I say, not feasible.
It was a one-day hearing, was it?
It was, my
judge. So a full day.
It was.
With half a day pre-reading.
With half a day pre-reading, yes, correct.
Thank you.
And just to see where Mr. Justice Bright ultimately came down on this, if we can please come to tab 14 in the same bundle, supplementary bundle 2. This is the judgment of Mr. Justice Bright on costs. The relevant paragraphs are 7 to 8 on page 285. Where his lordship, I might say, is quite robust in his findings. He says in the first sentence that the application for security for the award is one that should not have been made. Mr. Rishi put a brave face on things that did not escape my attention at the hearing, that before me, having been reminded of the amount of time available in the allocation that was necessary, the defendants chose, I assume deliberately, to allocate nearly all of their time to the application for security for costs, and hardly any of it to the application for security for the award. I am certain, albeit this is only an inference, that is because they had concluded that one had some prospects of succeeding and the other very little. Paragraph 8, I don't know what that view might have come to, when that view might have been come to, or what advice might have been given, but it seems to me that that was a view that should and could have been reached, and advice that should have been given, and possibly given long before the hearing started. So I submit respectfully that the notion that the Czech Republic is somehow at fault for not engaging with evidence that was never put in, or engaging more fully with a submission made in 9 minutes that was met with that type of finding by the judge, is untenable. My learned friend seeks to circumvent this by reference to the findings in Dalla and Newcastle Express. I think we only need to go to the latter. It's at tab 28 of the authority, volume 3. my Lord Justice Mayors, you will recall this decision, but you can see there in paragraph 15 the finding. A section 67, and pardon me, this begins just above B. A section 67 challenge involves a rehearing and not merely a review of the issue of jurisdiction. So the court must decide that issue for itself. It is not confined to a review of the arbitrator's reasoning, but effectively starts again. That approach was confirmed in Dalla, which also makes clear that the decision and reasoning of the arbitral tribunal is not entitled to any particular status or weight, although depending on its cogency, it will inform and be of interest to the court. Now, my learned friend emphasises the language at the end of what I just read to you. That language recognises that, in the context of a Section 67 challenge, when the court also has before it all of the evidence relevant to jurisdiction, the tribunal's reasoning will be of interest to the court, depending on its cogency. But here, the situation is very different. The judge was not in a position to reach a view on the cogency of the tribunal's findings, as he was not in a position to review the material underlying those findings. That is especially so given the way the defendants put the point on the note at the arbitration. As you might recall from reading paragraph 21 of our appendix in our skeleton below, the defendants mentioned the note in the memorial, and then the Czech Republic responded in the counter-memorial. These are the documents my learned friend showed you this morning. After that response in the counter-memorial, the defendants then did not mention the note again in their second written submission, or indeed in their opening oral submission, and only came back to it in their post-hearing submissions. I do think I need to take you to the transcript of what was said in opening by the Czech Republic, seeking to make clear or to learn whether or not this point was maintained by the defendants. In Supplementary Bundle 1, Supplementary Bundle 2, at tab 1, the relevant page is page 13 in the bundle. It's lines 11 to 17. At lines 11 to 17, the Czech Republic made this submission. Claimants no longer appear to be putting forward the baseless and insulting allegation that the Czech Republic bribed the arbitrators of the review tribunal. But in any event, these same allegations were made in the foreign enforcement proceedings which denied the effectiveness of the 2014 resolution, and no court has ever given them any weight whatsoever. Notwithstanding that clear indication that the case had been abandoned, at no point during the hearing did the defendants, the arbitration claimant, say that that was the incorrect position. The same point is also recorded in the Czech Republic's rejoinder written submission in the BIT arbitration. I would just give for the transcript. That's contained in footnote 1530, which can be found in Supplementary Bundle 2, tab 1, and page 10. Lastly on this point, my lords, my lady, I'm afraid I do need to clarify another point arising out of my learned friend's submission. He read this morning from a letter from solicitors for the defendants seeking confirmation that the security services were not involved in these proceedings. And there was some suggestion that that confirmation had not been given. That is incorrect. Solicitors for the Czech Republic, Arnold and Porter, confirmed in a letter dated 4 December 2023, so not long ago, just last week, that neither the Czech Republic security services nor the Czech police were involved in these challenge proceedings. I don't think that that letter is in the bundle, I'm afraid, my lords, my lady, but I did just want to mention that that point had been addressed between the parties.
Right, now how are you doing on time? Because we're approaching the end of the day.
I would hope to be done in 10 minutes, my lord. I've actually come to the end of the discussion about those 4 points that I want to start with, and they represent the bulk of what I want to say on the appeal. Now it is really just a few discrete points about my learned friend's grounds for appeal. I'll take grounds 1 and 2 together, and ground 3 separately.
All right.
Please.
Well, you do need to finish in about 10 minutes because that will give Mr. Green, at any rate, a few minutes to say something in
I'm
reply.
grateful. Grounds 1 and 2. I want to address the 3 points that my learned friend says are his principal basis in this case for advancing grounds 1 and 2. The first is that the judge erred in law by not having in mind section 1, subsection 1 of the Arbitration Act. Now, this is somewhat surprising. The defendants did not advance an argument by reference to section 1.1 in their skeleton before Mr. Justice Wright. So the contention that this is a key factor by reference to which section 70 subsection 7 is to be interpreted ought to be viewed in that light. In any event, the judge did have it in mind as the defendants referred to it orally and the judge confirmed that he had read it. That's at page 101 of the transcript below, which is at Supplementary Bundle 2, tab 13, page 237. At any point, as my learned friend touched on, this point does not assist the defendants. Section 1 applies to arbitration seated in England and Wales, and so does not apply to the Czech arbitration with which the defendants say there was interference. Given that Section 1 of the Act refers to object of arbitration, what it is talking about is arbitrations to which Part 1 of the Act applies. Section 1 thus cannot mandate, as my learned friend puts it, the court to consider whether there was interference with the Czech arbitration tribunal. The second point arising from these first two grounds of appeal is that my learned friend says that the judge erred in law by not taking into account public policy considerations. This is said to be an appellable error because the Czech Republic's challenge would substantively result in it restoring the effect of what appeared to be its own violation of fundamental norms of due process, the rule of law, and the object and purpose of the New York Convention. This is the public policy, the international public policy point. I'm grateful for that indication.
Well, you take your course, Mr. Bastian, because you've got to make your points and we've got to hear them in a very short time. If we don't get them on the transcript, then we don't get them on the transcript.
I'm grateful. The factual premise for such a contention has not been established. There has been no evidence and no argument that the Czech Republic's conduct was in breach of the New York Convention or any other norm or rule. That really is the end of the point. Indeed, we suggest that today there was something of a pivot by my learned friend. In his skeleton, the focus was on international public policy. And in that skeleton, he tried to create an exception to the existing test. That's why the discussion was about exceptional cases. But now today, my learned friend says that even applying the existing test, one can infer that the Czech Republic will avoid enforcement. Now, the references to the case law on dissipation are not in the bundle, I'm afraid. I'm sure your lordships and your ladyship will know the case in Lakatemia Shipping and Morimoto, which was decided in 2020 by this court. There it was quite clear, the court held, at paragraph 34, that it's not enough to establish a sufficient risk of dissipation by merely establishing an arguable case that the defendant has been guilty of dishonesty. It is necessary to scrutinise the evidence to see whether the dishonesty in question points to the conclusion that assets may be dissipated. It is also necessary to take account of whether there appear at the interlocutory stage to be properly arguable answers to the allegations of dishonesty. In those circumstances, the lack of any evidence of a breach of the New York Convention or a breach of a particular international policy is meaningful. It means, therefore, that as a ground of error, that submission cannot stand. My lords, there are three short points I wish to make about this second point on the first two grounds of appeal. As my learned friend adverted to this morning, we do say that it is not a logical point. My learned friend argues that the defendant's position will be negatively affected if the challenge to the award succeeds. But that cannot be a relevant consideration for whether to order security under section 77. It's not logical for the position that would eventuate if the award is set aside to be a justification for ordering security to the award. The second point is that we do maintain that my learned friend's submission is inconsistent with the defendant's position to date in their efforts to enforce the 2008 award. In enforcement proceedings, they suggest that the 2008 award remains enforceable. The defendants cannot, on the one hand, argue here that a successful challenge will leave them with a 2008 award that is a violation of due process, rule of law, and the New York Convention, while also arguing in enforcement proceedings that the award remains enforceable. Third short point here, my learned friend's points about wrongdoing in the Czech seated arbitration are indeed, we say, legally irrelevant to whether an order for security for the award under section 77 in an English seated, in respect of an English seated VIT award. That is because they have been ruled upon by the BIT tribunal, and that award, if it stands, provides the remedy. I do not resolve from what I mentioned earlier on that point. The third matter that my learned friend says the judge erred by not considering was the relevant international obligation. The essence of this argument is that when deciding whether to order security for the award, the judge should have taken into account an allegation that the claimant had breached the New York Convention by allegedly corrupting the tribunal in the prior Czech arbitration. We say that this does not assist. It suffers from the same faults as the public policy argument I just covered. It is also not being set out in evidence. That evidence does not advance any contention that by interfering in the commercial arbitration, there was a breach of the New York Convention. An appeal cannot lie in respect of a matter that was not in evidence before the judge. As a result, my lords, my lady, we say that the alleged errors of law by the judge in grounds 1 and 2 are not made out. Two very last and brief points on grounds of appeal 1 and 2. We heard from my learned friend earlier this afternoon a reference to the Mikula case. With respect, that case is not just distinguishable, it is entirely irrelevant. It was an award issued under the ICSID Convention. The ICSID Convention generates awards that are enforceable, recognisable and enforceable under an entirely different act in this jurisdiction. That's the 1966 Investment Arbitration Act. And the reason why that is significant is because under that act and under the ICSID Convention, England, as the United Kingdom, has an obligation to enforce those awards. So you have no equivalent or analogue to section 67, 68 or 69. And to try to transpose findings from the Mikula award, considering an entirely different legal and factual construct, into the proceedings here is not, we say, viable. Much as I think we all applaud my learned friend's success in that case, it is not one that is transferable here. The second and final point on grounds of appeal 1 and 2 is that my learned friend relies on Stati to say that his submissions are of particular importance when it comes to issues of fraud and public policy. But again, Stati is an entirely different context. There is a difference between an allegation of fraud being allowed to proceed to trial and a party being ordered to pay security for the award on the basis of such an allegation, I repeat, that has not been properly put in evidence. As I noted, my learned friend says that no final consequences would flow from allowing the application, but that may not be correct. When considering substantial awards, requiring a party to pay security in the sum of an award could be sufficient to stifle a viable claim. This was the exchange I had with your ladyship earlier this afternoon. That brings me, my lords, my lady, to briefly address the specific points on ground 3 of the ground for appeal. The starting point here is that the cases at first instance, sorry, my lords, my lady, I'll just pause for a moment. My lords, my lady, I'm pleased to say that I have covered much of the ground in relation to ground 3 during our discussions, in particular with your Lordship, Lord Justice Miles, and your Lordship,
Yes,
Lord
quite.
Justice Snowden. Therefore, the final point that I do wish to make is that were your Lordship and your Ladyship against me on jurisdiction, submission, and the appeal, there would remain a final decision for the court to take, which would be about the appropriate sum for the security. Our submission is that your Lordship should in no circumstances order security in the full amount of the award. I say that because the claimant, as in the Czech Republic, has a perfectly arguable, indeed we say stronger than that, Section 67 challenge. And it has Section 68 challenges which relate to the level of quantum that it's appropriate for the award to award it. The Czech Republic contends that the entire quantum in the award was derived by the tribunal, simply copy-pasting the calculation of quantum from the 2008 award, which importantly was not an approach to quantum that either party in the arbitration had argued for. We say that is therefore a breach of Section 33 of the Act. Further, another Section 68 point the Czech Republic advances is that there is evidence that 30% of the 2008 commercial arbitration award has been assigned to a third party, a point that the tribunal entirely failed to decide, and a point that the third party has recently reiterated to both parties in these proceedings. In those circumstances, where there is a robust Section 67 challenge, and there are Section 68 challenges that specifically relate to the quantum in the 2022 award, I suggest that the court should be sceptical of requiring the Czech Republic to pay a substantial security in the full sum of the award as a condition of maintaining its challenges. Of course, we say the court does not need to get that point on quantum, but I did want to register it. My lords, my lady, I'm grateful, and particularly given the pace that I took the last 15 minutes.
All right, well done. Thank you very much.
My lords, I hope you're brief. Couple of quick points. 9-minute point. 9 minutes was what I was left before reply. That was because I was relying on what Mr. Riches had said about the note. It's just factually wrong that the note was dealt with in submissions that took 9 minutes. It's not right. And the court can see it if necessary in bundle S2, tab 13 in the transcript of the hearing. Perhaps.
Well, we see in the judgment that quite a lot of what the judge has to say about the note is under the heading of security for costs.
Indeed, but the point was that Mr. Riches, KC, had been involved in the BIT itself, and that's why he took all of the points, upon which I then made just simply discrete submissions of law as to how those points should then find expression in relation to security for the award.
Yes.
And that was made clear. So it's paragraph 70, it's page 231, should the court wish to look at it, S2 13 231, internal page 78, it begins at the top of that page, and goes on to discuss it, and then learned friend is pressed on the point by the judge, page I think I've already taken the court to, which is S2, tab 13, pages 249 and 250. That's the short point in relation to that. Just saying that the note wasn't in evidence and all of those points, my lord, just not correct, I'm afraid. It's S2 tab 3. Miss Mallory's statement, which you were taken to, paragraph 29 on page 51. If one continues paragraph 29 to page 54, you get what's set out at the letter F, where the Czech Republic does, as a matter of evidence, answer the point on the note. And we see 2, 4, 6, 7, 8 and 9 lines down, I think it is, the Czech Republic's position is there's no basis to conclude that this is a reference to a bribe being requested. So it was, and the exhibit there referred to is the exhibit we have of the note itself, which is in tab 4 at page 62 in Miss Mallory's own witness statement. So with the greatest possible respect, the point being taken in relation to the deafening silence was they'd sought to put in evidence to explain it away, and all they had was the old trope about the fees being the same as subsidies, and that left a deafening silence in relation to what it was that the police and the security service, and I think BIS, I didn't point it out on the note, but the court will see it's common ground that the reference on the note at page 62 in that bundle, next to number little 3, it says arrow BIS PCR hold by the balls. BIS is the Internal Security Service and PCR is the Czech police force. So we respectfully suggest it is absurd to try and explain away that note without meeting head on with something. They're not saying, oh, unfortunately can't play tennis anymore because we're controlling his access to the equipment. They made no attempt whatsoever, nor could they sensibly, to explain away a critical factor, which is absolutely clear on the face of the document, which shows that this is corruption, dishonesty, and a derailing of the 2008 award by the review process by corruption of the arbitral tribunal. So it was an issue. It was an issue on their evidence. They put in evidence to explain it, and the evidence had a gaping hole in the middle of it, upon which we relied as the deafening silence and a note. In those circumstances, they're given a fair opportunity in their evidence to answer it. They're giving a fair opportunity in their skeleton argument to answer it, because they were under no illusions, as we see in tab 11 on page 172, paragraph 21, 4 lines down, D's rely on the document. So they knew. So this is because they know they're in trouble on the note, they're trying to say all these things about it. And if the selected documents they put in, which we allowed them to put in, didn't put in thousands of pages in response, as their high tide mark of why it wasn't an issue before the BIT, if that were correct, there would be a serious irregularity point available to them under section 68, but the BIT tribunal had quite improperly pursued a point that had been abandoned. And that would be a serious irregularity point, and they could take it, and they haven't. So there's nothing on that either, we respectfully suggest. The stifling point, my lord, so I'm taking them in no particular order, I apologise for that. But on the stifling point, it's a non-point, because you're always entitled to say, when the court's considering an application, that security be provided, whether for costs or for an award, that a balancing factor is this would stifle the award. And there's that famous case, I think, with Mr. Justice Gage, making the order in the Astra Holdings case, where he was told the only evidence was, we cannot provide this security, and if you do, it'll stifle the appeal. Mr. Justice Gage said, well, I don't believe you. And they provided the security. And then in the Court of Appeal, the first thing the Court of Appeal said was, well, he was right, wasn't he? So it's always an available argument, vividly illustrated in that case. And it's just wrong to say that this, what we're contending for, would do that. Just on the, on a couple of key points, can I just invite the court very quickly to look at what Lord Justice Waller said in Samarkand. It's where it's at A1 tab 9 141, and it's just sounding a note of caution about the in paragraph 30 at the bottom. Ultimately, the follow factors have persuaded us the Court of Appeal does have jurisdiction. I'm so sorry. Ultimately, following factors have persuaded us the Court does have jurisdiction. First, although there might be a temptation in the interest of speed and saving expense to construe any part of the language of the 96 Act in a way that renders all decisions on various sections where the Commissioner's Court is final, there's a distinction, and then he draws a distinction. It's a different distinction than the one drawn for our purposes, but just sound a note of caution that the court probably finds there. In relation to there are 2 points I wish to make which are adjacent on the point the court trying to do in 2 minutes or so, on the point of abandoning the flimsiness test. My Lord, what appears to have happened, just to be fair to the courts who referred to it, is Lord Justice Staunton's very sensible, there are the outer brackets and then there's the middle point. Flimsiness appears to have been just a shorthand for taking note of that. And then it seems to have got elevated into a test by being repeated by judges who respect each other. And it's sort of calcified into a hurdle that shouldn't be there, we respectfully say. There's a practical consequence which finds expression in this case very vividly, which is when someone makes a very complicated and complex challenge on sections 67 and 68, as they have here, we made a summary dismissal application in July of 2022. And because of the complexity of the issues involved, that was actually listed to be heard at the final hearing in January of this year. So because of the complexity of it, we've not been able to get that determined in advance. And that rather goes to your Lordship's point, on the either hopeless or... But it's a feature, a practical feature of if one has this flimsiness test and you have to do it in 1 hour, you go, well, I've got a couple of good points, let's chuck in 55 really bad ones. Never do that now. And just to put a bit of balance to your Lordship's point, that if it's not absolutely clear, you shouldn't do it. Mm-hmm. Respectfully suggest, actually,
well, you say that at the end of this 8-day hearing in January, the judge may say, finally, well, actually, I can now see there was never anything in this.
Well, he may well. We've actually had to agree, just to be sensible and efficient, that there's no point the judge determining summary determination if he's determining everything else.
Yes. So
we actually haven't had the benefit of that because of the complexity of the issues raised on the challenge. So that also speaks to abandoning the flimsiness point, because if you have it there, it means that we get put in the position. I mean, we would respectfully suggest that the judge took the wrong approach. It really should be a brief consideration, as indicated by Lord Justice Staunton and in one of the other cases. You have a brief consideration. If it's obviously valid and absolutely fundamental, then fine. It's obviously invalid, but that's all. Otherwise, you make it impossible, particularly where the judge said to us, with great respect to him, that Mr. Richards had to demonstrate flimsiness on every single point, rather than identifying some examples of obviously meritless things as a matter of forming an impression and leaving the other side to point to their best points. So, for all those reasons, respectfully embrace the court's dispensing with the flimsiness challenge and simply just repeat. We would invite the court to find that the situation of a state is different. You're not going to find it can't dissipate its assets. So that word doesn't apply. It can't diminish its ability to pay easily or sensibly. So one is left when it's a state looking at different matters, and its sovereign status as a state, which is invoked by my learned friend on state immunity, it is then relevant, peculiarly relevant, that it's used those sovereign powers domestically to do what we see on the face of the note. So we do say that it's shown itself for the purposes of the exercise to be undertaken under Section 77, to be prepared to take improper steps to thwart the proper enforcement of payment of the award. Over by about 1 minute or so, unless I can help.
No, well, thank you very much. We're not going to make any order now. We will reserve judgment and consider what it is that we need to say in any judgment in the light of all the submissions that we've heard, for which we are very grateful to all concerned, not only those who delivered them orally, but those who are also part of the team. Obviously, we will do that as soon as we can, but I'm afraid I'm not making any promises. We're now approaching the end of term, as you appreciate. All I can say is we'll get it to you, whatever it may turn out to be, as soon as we can. You will understand that it will come subject to the usual embargo, I'm required to say, even though I know that you all understand it, that the court takes that very seriously. In the light of whatever we decide, we will expect you to agree as much as you can about the order that should be made as a result, and any consequential matters. If you can't agree, then we will have short submissions in writing and resolve any points of dispute without a further hearing. That then concludes this hearing. Thank you all very much. And thank you also to the writer for keeping up so well.
Welcome, Patrick. Plan for Christmas? don't know how it happens. There's this sort of like universal agreement to make December.
Hellish as possible. I was in Lawrence Fox Friday. I was in Lawrence Fox separation trial. Friday in the court next door. And then,
So a lovely weekend.
well, I started literally at 8 o'clock on Saturday.
It's so tough though, isn't it? I mean,
Yeah.
because, this kind of
I know. It's always balanced.
when I think